trust is A trust is a structure through which your assets are owned and managed according to clearly defined objectives or rules. Now, those objectives or rules can already start happening even in your lifetime, which is one of the differences between a will and a trust. So a will, it takes effect after death, but a trust can start working, can start fulfilling those obligations now. Now, rather than asking, do I need a will or a trust, I usually encourage families to say, what am I trying to achieve? Am I protecting vulnerable beneficiaries, or am I providing a continuity plan for a family business, or am I just protecting my family assets, or do I want to manage wealth across generations? Now, in answering those questions, you will then know also, if this is what I want to do, then I need a trust structure. If it's just this, then I need a will. So those questions need to precede the decision of whether you want to do a will or a trust. So when you have those conversations, then you then know that you know which product to go for. Sometimes it may not even be either of the two. It may be that you need to set up, say, a holding company somewhere, or you need to set up a private foundation. When you do all of these things, the questioning, you would know what tool is important.
Thank you, Ma, for that answer. So at this juncture, I would like to encourage our audience to please, if you have any questions, please kindly drop it in the chat box, and you can also specify which speaker you would like your question to be directed to. We'll try to make some time towards the end of the session to take your questions. Thank you, everyone. So, Mrs. Odolami,
Yes, please.
my next question will be, when one already has an estate plan, I mean, we know that life isn't linear, things change. So, for example, in my now, maybe I'm not married, I don't have a family yet, and I already have an estate plan in place. But then years down the line, my circumstances change. How then do I, how often do you think, first of all, how often do you think one should review their estate plan? And then how do I go about updating my estate plan to reflect my present circumstances?
Okay. Thank you very much. So I'll say maybe every 3 to 5 years to review your estate plan. But there are some major things I should watch out for that when they happen, I think it will be time to review. Like you said, if somebody marries and had made a will before marriage, in some cases the will revokes the marriage if you're not prepared for marriage in the will. So, or you have a child, or you buy a new property, or you change job, your financial status changes, your assets, you've acquired more assets, you have more dependents, you have more dependents. Just for me, just generally, when life changes and maybe what you already had does not cover what you did. So I'll say your will should be updated to reflect your present circumstance. I think that is it. So at each point in time, your will should reflect your present circumstance, and that would help you because we've seen cases where wills were not updated and some children were not part of the beneficiaries in the will because the will was made before they were born. And that created some problems. So, well, in some laws now, they can go back to court, but won't be the same as actually the parent actually giving them something in the will.
Juma, while you were speaking, you mentioned something about incapacitation. So my question will be, having a power of what role does a power of attorney play in estate planning? Let's say I have chosen to use a power of attorney as an estate planning tool. What role does it play?
Okay, a power of attorney gives somebody else the power to do whatever it is exactly you say the person should do. So it could be limited, it could be unlimited, the power of attorney that you give the person. So if it's limited, like the example I gave of my father, he gave my mom the access to his uh, finances, his bank accounts and everything to decide whatever she could go to the bank and sign. In some cases, it could be health, like the person I said is ill and has a stroke and can't talk. So it could be in case I am ill, I want this person to be able to take decisions on my health circumstance, maybe decisions on what happens to me and all that. So the power of attorney gives somebody else the right to take decisions on your behalf, depending on whatever power you give that person. I hope that.
Thank you, Mrs. Odulami. I hope we're all learning a lot. So my next question will be directed to Mrs. Olumide. Now, we know that this is the social media age, and of course, with social media age, we've seen a rise in different things. So we've seen a rise in virtual assets, digital assets, cryptocurrencies, NFTs, and things like that. In fact, now a lot of people use social media to as social media is basically their source of income. They'll tell you that their social media accounts, that is their brand, that is where they eat from. Now, with the rise of these digital virtual assets, how can if, for example, let's say I'm an influencer and that is my source of income, how do I bring that under my estate plan? Because I consider that an asset for me. How do I bring something like that under an estate plan?
Absolutely. It's an asset. Our lives today now extend beyond physical assets. Digital assets now form a part of it. And your estate plan has to evolve with the way you live. So being an influencer, for example, what part of it have you registered? If there's some form of registration that needs to take place. So for example, if you wrote a book, your literary works, have you registered them? Do you have a copyright over them? Do you have a particular logo or a name that you want to trademark? Now, when you begin to do those registrations, you then also ask yourself, who owns that license, or who owns those rights? Am I putting it in my personal name? Do I want to put it in an entity that is then owned by maybe my private foundation or my trust? That way, you are still able to protect it beyond you. So if you were getting royalties or anything from there, it still comes in to your estate even when you're not there, or it still comes into your estate at the time when you're there, and you're able to use the resources for other parts of your lifestyle. So I would say that, the registrations for these ones, maybe the registrations may come in first, and then documenting how or who owns those interests and how those interests should be used, or how those interests should be passed to the next generation.
Thank you for that, Ma. I know that working at the Legacy House, you work with not just families, but you also work with businesses, lots of businesses. So I would say that what considerations do you think what are the things a business should consider before creating some form of structure?
So I know that founders spend, because I'm a founder as well, so founders spend many, many years building their extraordinary businesses, but very few people spend that extra time to plan what happens if they are not there. And not in there, I don't mean death. I mean, for example, you could start a business and decide that you now want another interest and you want to move out of that business, but you still want the business to run. Which is where succession planning, business continuity plans come on board. So business owners need to, from a very early stage, need to start asking who owns the business. Now, the fact that I'm the founder doesn't necessarily mean that I own it solely. So am I owning it? Do we want this to be a family business? Family business. So your family business can be owned by the family, or it can be controlled by the family. Both can be separated. There are some family businesses where the family doesn't own shares, but they control the business, meaning that very, very important decisions cannot be taken without that family say. And so it's still a family business because they control it. And then we now move to who manages the business. The family don't have to manage the business for it to be a family business. So you're asking that as well. And then, of course, decision making. And then what will happen if I step down? Which is why we usually say start your succession plan before your 50s or before your 60s, so that the next generation of leaders, and when I say next generation, I don't necessarily mean the children, because it's not in all circumstances that your children want to be involved in the business. However, it's important that if it's a family business, they have an ownership mindset towards it. And the ownership mindset can always be built by, you bringing them in for internships or bringing them in to even see you in the business from a very young age, from 8 years old or 10 years old. They already know that, oh, the family owns this. They don't have to manage it, but they have that ownership mindset. Now, if you ask these questions on time, you can then begin to do your succession plan, your business continuity plan, where you're saying, no, at a particular stage, we need professional managers. Or if my son has been in the business, if he has gone through the ranks, he can rise to being CEO. You then begin to put in your family constitution, for example, how do children become a part of the family business? How do they rise in leadership? So all of these things need to be put in place at an early stage. Once I think at the point where you're already coming into your 30s or 40s, you already have children, you already know that this is an established business. You want to start making plans towards the next generation of leaders so that you can have business continuity. Yeah.
Thank you, Ma. That was very insightful. Mrs. Odulami, Zulum she spoke about, planning for your children and having a plan in place to protect them. So my question would be, how can parents of young children ensure that their children are adequately protected, ensure that if something happens to them today, their children are taken care of, there is something in place to ensure that their future isn't put on hold or their journey isn't put on hold?
Thank you very much. For parents of young children, it's really very important. It's even more important than their assets, because their children, what happens to their children in case they're not there, is more important. So I'll say, look around. Who are those people that you can leave your children with, that you can go to sleep and leave your children with? So, and then apart from that, also, are there people that will be ready to take on another child? Because whilst you are there, it's easy to just drop your child with somebody for a day or two and nobody knows you are coming back for that child. But is it somebody that would go all out to look after your child whilst you are not there? Or is it somebody that is just because you are there? That's why the person is doing that. So, and so you take it, and then so you don't necessarily say, because the person is my friend, is my cousin, is my sister, this person will take care of my child. So after you've looked at who are those who can, then you now appoint a guardian for that child in whatever estate plan that you're making. And then the estate plan also, when you appoint the guardian, is also advisable to appoint another person in case that person fails. So you have somebody who can step in. And then it's also advisable to actually, particularly because minors, they can't decide for themselves. Is that, and then so there are maybe schools that you want them to go, plans that you already have in mind for them. State it out clearly, so there's no dispute. There's no this is what I think. That's too expensive. This is so. If possible, state it out clearly. Have guidance for those children. Appoint different that alternate guardian for them, and then decide on which plan will be good for you, either a will or a trust. If it's a will that will just say, this is the person I want to appoint, and this is the person that will be alternate, or if it's a trust that will say, pay for their school, this is what you're supposed to do at each time in their life until they are a certain age. So it depends on, so for minor children, it's better to spell it out and be detailed. So there's no there's no what am I looking for? There's no regrets. There's no way that you now, because you didn't spell it out, those children will now suffer because you are not there.
Thank you, Ma. And I would like to follow up by asking that how can families reduce the likelihood of disputes when a loved one passes away? You mentioned the fact that when you don't adequately plan for your children, some form of dispute might arise in terms of their care. So when a loved one passes away, how can families reduce the likelihood of there being disputes, taking each other to court? I mean, we've heard so many examples of wealthy families that the patriarch will pass away and then the children drag each other to court 20 years, 30 years, they're still there, they're still fighting, and the assets are basically just wasting away. So how can a family reduce the likelihood of disputes when a loved one passes away?
I think the way a family can reduce dispute is what we're discussing. If you have your estate plan in place, if you have either your will or trust in place, and everybody knows this is what this person has said, the way it should go. And then particularly, it's really good, particularly if you have a polygamous family or a large family, because, so make it detailed, be specific. Because I know of somebody who I heard just said, my wife's this, and then all my children should share this. And the eldest child just took over and did whatever he wanted to do. So I'll rather say, if you don't want disputes and even if you don't have a large family, be specific as to what you want to give a particular person, how you want them to be shared, what you want them to do, and who you want to be in charge and who you want to go. So give details. Don't assume, don't make assumptions, and that will help. And if possible, like the film I said, it might be a film, but the man actually had a video. Because if he had not, I'm sure the children would have said, no, it couldn't have been the first son. It had to be the first daughter who had been running so know the dynamics of your family and prepare accordingly to avoid disputes in future.
Thank you, Ma. Mrs. Olumide, for someone that's, because I'm sure we have some participants on this call that are probably hearing about estate planning for the first time. So for someone that has never actually sat to think about planning their estate, how would you advise they go about it? Or how do you advise someone to go about it?
Fantastic. So this may surprise people, but I usually say don't start off just saying I want to draft a will or do a trust or a legal document. I sort of alluded to this earlier where I said start with visibility. Ask yourself some questions. What do I own? How is it owned? Is it owned in my name? Did I own it? Did I put it within a company? Do I co-own it with somebody else? Who depends on me? So who are my dependents? Is it just my children? Do I have aging parents? Do I have siblings? What happens if I'm not here tomorrow to all of these things? Now, once you understand your ecosystem, that's for you, because no two estate plans are the same. No two strategies are the same because it still has to reflect your own values, has to reflect your objectives as an individual, and if you're a family, as a family. So once you understand your own ecosystem, you can then begin to create the right structures. And structures doesn't have to be anything too glamorous. It may just be that you need to register a company that is doing investments for you, or you need to set up a trust, or you need to appoint a power of attorney for your young children to say, well, I'm appointing this person as their guardian, just in case, especially if you fly a lot. For example, for people who, they're flying a lot and, with all of the news that we hear, or you think you're not readily available, you want to already appoint a guardian. So that may be the structure that you need now. As your life gets more complex, as you progress in life, you would know typically how to layer on more structures, because you would then find that you need more to accommodate your current reality. So visibility first, then align that visibility with your goals, and then the structure can then come after that.
Thank you, Ma. You mentioned something when you started. You said no two structures are the same, and you have to tailor your structure based on your assets and what you have. So my question will be, so I'm guessing that means that you can actually make a mistake when planning your estate if you do not consider the assets you have. So what common mistakes will you say people make when they are planning their estate?
I think for me, one common mistake is usually waiting too long. People wait till they've accumulated a lot of assets, a lot of interest, and the things are beginning to get complex, things are beginning to get convoluted, and then they then begin to just do different documents. So you have a document in Mauritius, you have another document in Nigeria, especially for those who have assets in different jurisdictions. So first, the thing to know is that documents alone don't solve this problem. Failing to update your estate plan is another thing that people, that is a common mistake. When there's a major life event, you want to quickly update it to say, oh, if I now have a new child, or if I now have a new business, where does this fit into my estate plan? Am I putting this under this structure, or am I including this person in this list of things? So updating the estate plan is one common mistake that people have. Another common mistake would be ignoring the business side. So some people are focused solely on the family and they're not even thinking about the business to say, if today someone is unable to make certain decisions, does the business shut down if you're not there? So people ignore that business side. People also do not communicate their intentions. Zodulami mentioned it. She said that it's not clear. You can't just say all my children. It has to be clear. It also has to be clear how you want it to be handled. We have a 90-year-old client who has said, oh, none of his real estate should be sold. And he's very specific. People need to be specific. There's someone else that we had a meeting with, and he said, oh, if his child doesn't attend Ivy League schools, he listed the 4 Ivy League schools. That's a part of her inheritance, so to speak, or a part of the trust funds that he had set up for her would be reduced, would be removed if she did not make it to any of the Ivy League schools, because he knew what he had put in place to ensure that she would attend those Ivy League schools. So not communicating intentions is also another common mistake. So I'll say that success creates complexity, but where the structures are already in place, there will be some alignment. And then, of course, with the alignment, you are then able to build continuously upon that.
Thank you very much, Ma.
Yeah.
This is just a reminder to our audience that if you have any questions, please do not hesitate to drop them in the chat box for us to answer. So I think at this point, we'll take a couple of questions. I've been seeing a lot of questions dropping. So we'll take a couple of questions from the chat box. And so the first question, I will direct it to Mrs. Otolami. The question says, what is the cost implication of planning an estate for a will and trust? Is it a one-time payment or annual fee? And in case there is need to make changes, do you pay for the changes?
For a trust, it's not a one-off thing. I think it's because you pay the trust for management of the trust estates. So it's not a one-off thing. Sorry, what was the other part of it? Because I can't say this is how much anybody charges. It's like saying, how much will a lawyer charge if I go and ask for this? So it depends on the particular trustee. So I can't say this is how much they charge, but I know that the charge is not a one-off thing. It's a continuous thing. You're muted.
The person also asks that where there is need to make changes, process, and whether there are payments involved where you need to make changes to an already existing plan.
I would assume there will be changes. That's additional work.
Yes.
It's like going to a lawyer and say, because I have this document with you and I want to make changes, and so it's free of charge. It can't be free of charge. It has to be additional payment. It's just that I won't be able to say this is how much will be charged, but definitely it's additional payment.
Thank you, Ma. For Mrs. Olumide, a question was asked about the holding company, that how can one use a holding company to plan their estate?
Okay, so a holding company just like the name implies, should hold and not be involved in business activities. So it's a holding company because it is warehousing. So it could be a holding company for your real estate. It could be a holding company for your investments in startups. It could be a holding company for any other kind of asset. So a holding company is just supposed to hold the asset for you. How this plays into your estate plan is who then owns the holding company. Are you holding it in? So is it just are the shareholders, for example, you, your wife, your kids, and then have you then put a plan in place where you say as the kids come of age, they become shareholders and then they become directors so that they can make decisions. Also, some of the documentation within that holding company would also help in decision making. When the holding company has these assets, how do we manage the assets, or do we distribute the assets at a particular point? Who can we admit as members of this holding company? So yes, the holding company is a very good tool within your estate planning.
Thank you, Ma. How much assets I think we've answered this question of how many assets one should have before considering planning their estate. And I think our speakers have both concord that you start with what you have. So I'll ask another question. In what situation would you strongly recommend a trust over a will? And are there tax advantages to setting up a trust compared to a will?
So I'm more on the trust side, because of the publicity or the public nature of a will. A trust is typically private. The will can be disputed. You can have a trust and nobody knows you have a trust. So the dispute risk for that is really, really minimal. A trust can also be included within a larger structure or a larger structure within a trust, as against the will is a bit limited because it comes into play after death. But your trust can come into play now. It can begin. In fact, this is why we have trust fund babies, because their parents did set up a trust and then put a fund together within the trust. So a trust has so many advantages over a will. You decide which one you want. I'll typically tilt you towards a trust. But then the nature of the trust also matters. How you set up the trust also matters. Your trust can sit within a family foundation, where the family foundation, can be appointed as your corporate trustee. So many layers can come within that trust structure. Or you can appoint, First Allied trustees, for example, as your trustees, for your trust. So different trust structures, but it would depend on your family's goal, your objective, and then you would know which one to go for.
Thank
Could
you,
I just add to that? I
Of
think,
course, ma'am.
yes, I think a trust will be okay if you have assets you want to continue. If I have just a house I want to sell, if I have something that is just finishing, ending now, you don't need a trust.
Yeah.
If you just need to distribute something that is not continuous, you don't need a trust.
Yeah.
If you just want to give out your assets, you don't need a trust. So it depends, it depends on what you need it for. So trust is more like for larger assets, continuity, and all that, than I just want to share. I have shoes here. I want to give it out. You don't need a trust for that. So it depends on what you need it for. Thank you.
Thank you, Ma. Mrs. Odolabi,
Yes,
I know you've spent quite a number of years in civil service. So with jointly owned assets, how do you treat them under an estate plan? Let's say I and my husband, we bought a property in both our names, or we have joint accounts. Now we want to create an estate plan. How do you treat jointly owned assets?
For jointly owned assets, I think maybe I should start with the land or for property. So it depends on how you own it. It's either joint tenancy or tenancy in common. So if it's joint tenancy, that means both of you own it together. And when one passes, the other one automatically owns it. But if it's tenancy in common, so in that case, you can't even will it out to any other person because you both own it, kind of, except you have a joint will. But if it's tenancy in common, that means I have a certain percentage, the other person has a certain percentage, and so you can give out your percentage to somebody else. But if not, then you can't give it out to another person. And so if then you can give out your percentage to the other person. That's the way. If it's tenancy in common, that's how you can do that. And for the accounts, so you ask for if it's a will.
So I said if for in a situation where maybe they have joint bank accounts, how can they be? How does it come under an estate?
If it's joint bank accounts, then even if it's not even your husband or wife, like I am a co-signatory with my mom now. If anything happens now, and she goes, since I can sign, then automatically I just continue. And I have one with my son because I was looking for a way that if I pass, I don't have to go through nobody. They can just go to my account and do something. So if it's joint accounts, that is easy. The person just takes over because they are, except you, and there's even no way you can be joint, except you say both of you must sign. And then that's when you now give yourself problem. But if one person can sign, then the other person just takes over. And if it's an asset, if it's land, I've explained, it depends on how the title of deed, what it specifies, either it's joint tenancy or tenancy in common. That's how you know what you are allowed to give out. I hope that answers the question. You're muted
Yes.
again. Okay.
Yes, it does. Thank you, Ma. Please, I'd like us to give a virtual applause to our speakers. I'm sure we have all learned a whole lot from this session. And just before I give it up, I would like to ask our speakers one last question, which is that if you were to leave the participants with one thought today, what would that be? So we'll have Mrs. Odolami go first and then Mrs. Olumide. Just one thought for our participants.
Okay. I think from all what we said, estate planning is not about death. It's about how do you protect lives? How do you preserve your assets? How do you care for your loved ones? So for me, please don't think of estate planning as, I don't want to die. Think of your loved ones, protecting your loved ones, protecting yourself, and protecting your assets. Thank you very much.
Thank you, Ma. Mrs. Olumide.
Yes. So for me, I would say that estate planning, the goal of estate planning isn't just to simply pass on assets. It's to pass on much more than that. The coordination, stewardship, and even peace of mind. You don't want the next generation, or you don't want the next set of leaders after you to be in chaos, which is why, properly documenting things and putting structures in place on time is very important. Successful families are not built by the assets that they accumulate. They are built by the systems that coordinate those assets. And this is around a shared purpose. And that's what I usually call a family office mindset, where you already have a system that coordinates your assets within a shared purpose. And I believe that it is one of the greatest gifts that we can leave with this generation. Thank you.
Thank you very much, Ma. Thank you very much to our speakers. We have all learned a lot. Now I'll hand over to my colleague, Nwamaka Etogu, our Trust Services Manager, to speak about our services here at First Ally. Nwamaka, over to you.
Thank you very much, Busayo. Thank you, everyone. Okay, thank you very much. As we bring today's webinar titled Putting Your Affairs in Order, Essential Estate Planning Tools to Consider, to a close, I would like to sincerely thank our speakers for this very insightful presentation and every one of you who have taken time to join us today. We hope that today's session has reinforced the importance of planning ahead, not waiting till you've accumulated all your wealth, like our speakers have rightly said, not being held back because you feel you're a certain gender or you're a certain, wealth class before you start to put this estate plan in place. At First Allied Trustees, we are professionally equipped to guide you in choosing the appropriate estate planning solution that best suits your unique needs, your family dynamics, and your long-term goals. First Allied Trustees is the trust subsidiary of First Allied Capital, and we are a fully equipped firm, a trustee services firm, and we provide private trust services, which is what we're speaking to, whether it's a range of trust products, which will go from our living trust, which encompasses the entirety of your assets in terms of taking care of the welfare of your children, your loved ones, every type of asset, a mix of your tools, whether your wills and your trust, whether it's specifically to just your children's needs, which will be our children education trust, or a retirement trust, which will just be you building up that wealth and giving instructions as it relates to maybe your medical needs and your retirement as a whole, or our will writing or executorship services, or even our gift services. Recently, we launched a digitized will instruction service. The service just helps you to take on this, to take you'll write your will, but to take that instruction from anywhere you are. It is easy, it is convenient, and it helps you to, it is faster than, taking it physically. So our will services and our link to that service has been posted on the chat box. You can just click on that link. The link is also available on our website. It's also available on the forms, the Microsoft forms that we have been sharing on the chat box. If today's webinar has inspired you to take the next step, we encourage you to reach out to us. I know some questions were not answered on the chat box. Some questions as it relates to fees, what it typically entails to either write a will or set up a trust. All these questions we can answer on a one-on-one session because, as our speakers have rightly enlightened us, each person's solution differ depending on your own type of asset, unique family dynamics, and your own, special long-term goals. So on the back, as you see being displayed, is our will service, which I just spoke to, and our children education trust. If you're interested in just creating a trust for your children. So we encourage you to please reach out to us. Our numbers are on the post, on the chat box, and on the flyers. We'll be delighted to help you put your affairs in order with confidence. We thank you very specially. Thank our participants and our speakers for joining us today. We thank you and we hope to hear from you shortly. We've been getting some forms. People have been sending out forms and we'll reach out to you immediately after this call. Thank you so much, everyone, and have a wonderful day. We look forward to serving you and to handhold you on this journey. Thank you, everyone. Bye.